Hello, everyone. I'm Yu Fan from UNESCO Bangkok. Welcome and thank you all for joining the Open GLAM webinar series on universal access to documentary heritage in Asia and the Pacific. This is a webinar series organized by UNESCO, MoCap, and Open GLAM Creative Commons. I'll accompany you all throughout this session today and introduce the speakers to you all. So first of all, I'd like to thank all the speakers who are here today, who are so nice to share their knowledge and experience on copyright and open access. Copyright questions are at heart of every open access decision, and understanding what it is in copyright and what is in the public domain is key to provide open and unrestricted access to digitized work and cultural content. The speakers today will introduce the most important copyright issues. So I'll share the slide. So this is a beautiful banner that I made for this session. So before the presentation starts, let me share with you some housekeeping rules of this webinar. Could you please change the slide, please? Okay. As an attendee, your microphone and video will be disabled during the whole session, but you can use the chat box and as well as the Q&A function on your Zoom settings to ask questions. You can also use the chat box to say hi to your friends. The webinar is being recorded. We will share the recording or the transcripts of the session of the webinar series on the internet. So please follow UNESCO Bangkok's website or social media platforms for further information. And the Q&A session will be in the end after all four speakers finish their presentation. Please use the Q&A function or leave your questions in the chat box at any time. If you have a very quick question, directly refer to the presentation made by a speaker. I'll let you let the speaker address the question directly after his speech. Otherwise, for longer questions, we will leave them and I'll collect them and we'll leave them all to the Q&A session. So, okay, without further ado, I'd like to introduce our first speaker today, Dr. Tomoaki Watanabe. He's an academic studying information society issues and ICT policies. He has worked in many areas related to openness and open licensing, including social dynamics and quality assurance issues of Wikipedia, open data policy formation, innovation through open design and digital fabrication, copyright issues related to digital archive. He has been involved in Creative Commons Japan for over a decade, and he's a co-founder of Open Knowledge Foundation Japan. He's professor, executive research fellow, and general manager for research division and Center for Global Communication at International University of Japan. Professor today will talk about the basics of copyright law, including how it works, what is copyrightable, and the global aspects of copyright. So, Professor, the floor is yours.
Thank you very much for the introduction. And for the benefit of time, I'll just move right into my talk on the copyright basics. And let me see. No. Okay. So I guess you see the slides. Okay, yes. So today I'm going to cover just four basic things. What is copyright like, and what is under the copyright or subject of the copyright, and what you cannot do as non-authors or non-right holders. Or in other words, what copyright law prohibits you from doing. And then some global or international aspects of the copyright, especially relevant to Asia Pacific. So the first issue is, what is copyright like? So the basic property or characteristics of the copyright is that it's a right, and exclusivity is its characteristics, main characteristic, and it's in a way kind of like a property right. In case of a property right, you control a physical object, the property, but in case of a copyright, it's not a physical thing. So when you have a copyright in a novel, it's not that you have some rights over all those books where your stories are printed, but you have the story. You have the right to the story. If someone wants to copy it, they need your permission. If someone wants to make a cinema out of it, they need permission from you. So that's the kind of right that copyright is. And copyright is actually a bundle of many different kinds of rights, and some rights could be sold or transferred. And also, a license could be provided to others so that others can use the work, like providing some um, um, license to print extra copies or publicly recite the story in front of some large audience, etc. So that's like the basics. And then the copyright is time limited. Um, the the basic global standard is author's life plus 50 years. In some countries, it's plus 70 years, not 50. Um, and after that duration, any so-called copyrighted work uh, will fall into the public domain, which means basically anyone can use the work in any way without anyone's permission. So that's the copyright. And then um, the right is gained upon creation, so it's kind of automatic. Say if you know the patent system, for example, you need to apply for the patent, and you have to go through some review process. But copyright doesn't require that kind of stuff. There's no formality required, so you might see so-called copyright notice, including the circle C mark with the year and the name of the author. Such notice is not actually necessary in order for you to get a copyright. You just need to create something, and copyright will automatically be gained by you. In some countries, not just creation, but also fixation into some tangible medium might be required. That's a variation, but basically, there's no procedures or formalities. And then, so now next is the point about what is under the copyright. Um, in general, copyrighted work is anything that is minimally creative. It doesn't have to be super creative. It doesn't have to be like unique. It doesn't have to be historically the first of its kind. And it has to be some kind of expression of some ideas. More specifically, it includes music, literature, architecture, painting, sculpture, cinema, photographs, maps, screenplays, dance, speech, etc. Um, and copyrighted work is not, uh, it doesn't include things like very common greetings, like hello. If someone has a copyright on the phrase good afternoon, then you need a permission from that copyright holder every time you wanted to say the phrase. But fortunately, copyright doesn't work that way. So very common greetings is considered not creative enough, so anyone can use it. Also, bare facts like room temperature, population statistics, stock prices, that kind of stuff is not expressions. it's not minimally creative. So usually it falls out of copyright. Many of the numerical data might, for the same reason, fall out of copyright. And also, ideas themselves are not within the scope of the copyright. So you can express the same philosophy using different treatises, for example. You can tell very similar story uh, in the sense that abstract storyline is the same, but expressions are different enough, then it's okay that you create another story like that without the original story's author's permission. Naturally generated patterns like natural scenery is not part of the copyright. So now I move on to the regulated actions. What you cannot do when something is copyrighted. Um, and most apparent is copying or reproduction. Also, creating adaptation is another thing you cannot do. And then publicly performing something, say screenplay, or publicly communicating the performance, that's also something you cannot do without the copyright holder's permission. Broadcasting, also the same. So all those things you cannot do without the permission or without the license. And in some cases, and this depends on each country's legislation, but there are exceptions and limitations of copyright so that you can use others' creative works without permission. For example, in many countries, you as a teacher can use existing published works, part of it, by quoting it in the context of teaching. That's usually the case because many countries have some exceptions allowing um, uh, such use without any explicit license. All right, and then so from all these, there are some major implications for open access and digital archives. One, I think it should be rather clear. Many um, creative or intellectual works are minimally creative and expressions so that they are copyrighted works. And regardless of, say, author's intentions, authors do gain copyright because they don't have to apply for anything. They don't have to declare any intent. It just happens to them that they gain the copyright when they create such material. And that means digital archives or open access repositories, those things usually need a license from the authors, or if not the authors, the copyright holders other than authors, uh, to copy the material and publish them online, making available online for the publics to access it. But because copyright has the certain limited duration, when something is very old enough, then it may no longer be protected by the copyright. Protected is a jargon. Protected by the copyright means there is some effect of copyright so that other people cannot copy or do some other things without the permission. So that is the major implications. And then this is a tricky part, but very important part. When you don't know how to contact the copyright holder, and it happens with lots of old materials, it may be a problem because in order to make copies, in order to make available some of those materials, you may need a license. And in order to get a license, you need to contact the copyright holder. So uh, you face a trouble in such a case. And also, I forgot to mention this, but uh, closely related issue is when you don't really know for sure who is the copyright holder. When the work is very old, for example, the author has had deceased, um, presumably some of the descendants inherited the copyright, but you are not sure. And um, in that case, you start not from looking for the copyright holder's contact information, but you need to start from identifying how or exploring who is the copyright holder of a given material that you wanted to use, say in your repository or in your digital archive. And then um, there may be some special system to handle such case to allow some use of such works when even when you don't know the author, when even when you cannot contact the author, and those things are often called orphan works, in a sense that you don't know who the right holders are, and um, I cannot go into the details, and the systems vary country by country, and also there are some ongoing reform efforts in multiple countries and regions. So um, uh, I just let me say that if you do face this kind of problem, make sure you check with the expert on this particular issue. And then finally, global aspects of copyright, especially in relation to the Asia Pacific region. Number one, Berne Convention is it's like the de facto global standard. Well, okay, I shouldn't say de facto, but because it's a law, so it's a de jure. But it's an international treaty on copyright, and it started in the 19th century, very old, and virtually defines the global standard. Even though there are exceptions, but there are more than 170 member countries, signatories of this particular international treaty, and it sets certain minimum standards, such as the duration of the copyright is at least the author's life plus 50 years. The scope of the rights include right to reproduce, right to make adaptation, right to the public performance, etc. And also, it clearly says all the literary, scientific, and artistic works fall within the domain of the copyright. So those things are defined by this particular very influential international treaty. And then, and I'd say the reason why I can speak about copyright law today is because there is such a minimum standard and it's such an old law that copyright law, compared to some other legal systems, are relatively similar to each other across countries. And because of that, I can reasonably assume, oh, many other countries have similar uh, characteristics, and I can speak about copyright laws in general by addressing these points. Um, Also, the Berne Convention is made somewhat influential because of the World Trade Organization. WTO has this thing called TRIPS agreement, and through which the signatories of the agreement is basically obligated to follow the Berne Convention. So again, making the already influential Berne Convention even more influential. And then finally, and this is my last slide, I believe, uh, there used to be, if you go back, say, 5 years, an active discussion about Trans-Pacific Partnership involving Asia and Pacific countries, multiple countries. And that included chapter on intellectual properties and included some changes in copyright law, including its enforcement. Basically, the IP chapter didn't materialize as a part of the TPP agreement, so that copyright law didn't change as a result of this TPP, as I understand. But this kind of international trade agreement is an increasingly influential venue in bringing the changes to copyright laws in many countries. And uh, uh, to some people like me who follows the copyright reform issues, it is quite problematic because when you see copyright reform discussions domestically, you can easily say, "Oh, here's this discussion going on," say at the parliament or at some particular branch of the particular part of the executive branch. But trade agreement negotiations in general traditionally has been very secretive. It's kind of like a closed room deal making. And compared to that, even the international dimension of copyright treaties or laws tended to be much more open and transparent. So even NGOs may be able to participate into the process and the discussion, and we kind of know what's discussed, how much disputes are there or agreements are there. But trade agreement negotiations are totally like a different animal when it comes to transparency and participation. And also, in general, in this and other international venues or channels, there tends to be this dynamic or tension between exporter or exporting countries of copyrighted materials. Say, certain countries export a lot of movies to other countries or a lot of computer programming to other countries. And they tend to want more expansive copyright law, stronger rights, longer duration of the right, and stronger enforcement on piracy or illegal copying. Also, in contrast, developing countries are often importers and they are in need of greater liberty to access and use those copyrighted works. So there tends to be some fundamental tensions. Of course, if you watch some individual countries, like say even the U.S. started as an importer in the 19th century of some of the cultural works from the Europe, but eventually became the exporter. So the positions change if you look at the specific countries over the time of the history. But there tends to be always this tension. Okay, so I have spent more than 15 minutes now, and my talk is done now. Thank you very much.
Thank you so much, Tomoaki, for the very comprehensive introduction of copyright. So please, everyone, I would like to remind you that if you have any question with regard to what Tomoaki just presented or any other questions that you are curious about copyright and open access, please use the Q&A function or leave them in the chat box. Okay, so now let me introduce our second speaker today, Elliot Bledsoe. He has more than 10-year experience in copyright. He advocates for the public interest in copyright and for increased copyright literacy in the arts and cultural sectors. Currently, he works part-time with Australian Digital Alliance, and he's the copyright officer at the Australian Libraries Copyright Committee and the co-lead of the Australian chapter of Creative Commons. He also runs a communication micro consultancy focused on small to medium arts organizations. Elliot will give an overview of the main elements that cultural institutions need to consider when doing rights assessments to release their collections. So Elliot, please take the floor.
No worries, thank you. Thank you for the introduction. I'll just share my slides with everybody. Can I just confirm that you're able to see my slides?
Yes.
Yes, great. Alrighty, well, thank you very much for the invitation to participate in today's webinar. As was mentioned, I'm the Copyright Officer at the Australian Libraries Copyright Committee, which is a policy and advocacy body that looks at the role of copyright and the needs of the GLAM sector, the galleries, libraries, archives and museum sector, in relation to their kind of work as cultural memory collections and the interplay between that kind of work and the kind of interplay of copyright and how it impacts the material in their collections. So just before I get started, I would like to acknowledge that today I am presenting from the traditional lands of the Turrbal and Yagara people. They're the custodians of the land here in Brisbane, where I'm based. And the ALCC and myself pay respects to their elders past, present and emerging. And I extend that respect to any Aboriginal and Torres Strait Islander people who are with us today, and to all Aboriginal and Torres Strait Islander people, their communities and their cultures throughout Australia, and First Nations communities around the world. Copyright is a legal protection that's designed to encourage the sharing of knowledge, ideas and culture. It's important to recognise and respect that Indigenous peoples the world over have been sharing knowledge through networks for hundreds of thousands of years, and that Australia has a long and rich history of storytelling, starting with our First Peoples. Also, I'd like to just let you know that this presentation is available under the terms of a Creative Commons 4.0 Attribution International License, which means that you're free to copy and redistribute it, and you can make any modifications or adaptations to it that you like, as long as you acknowledge the Australian Libraries Copyright Committee as the copyright owner. Alrighty, let's get started. So we know that copyright is about protecting creative content. Tomoaki has already provided an overview of the type of material that's protected, and the kind of underlying premise of that is about the need to support and encourage creativity in the community. Copyright is meant to be about providing a balance between the need to incentivize creativity by allowing authors to make money from their creations, while also encouraging the dissemination of that knowledge to the public through publication and sharing. So in lots of ways, copyright as a balance is meant to be a win-win. It's designed to balance these competing interests. And when we talk about the idea of the public interest in copyright, we're talking about this kind of sharing of knowledge concept, which is a kind of fundamental tandem component to copyright to the kind of monopoly rights that are granted to creators. So as was mentioned, I'm going to talk a little bit today about the kinds of things that cultural collections should be thinking about when considering the copyright implications of material in their collections. So I've framed it around the idea of a series of questions that you should think about or ask yourself in relation to material in your collections. So hopefully that will help give you a solid kind of guiding set of principles or questions to ask yourself in order to think about the potential copyright issues that might relate to a piece of material in your collection. So the first question you need to ask yourself is whether the material is protected by copyright. So I'm not going to go through all the types of material that are protected by copyright. Tomoaki has already provided us with a comprehensive overview of that information. But the first question, as I said, that you need to ask yourself is whether the material is actually within the scope of copyright? Is it something that is protected by copyright? So while we have gotten a good overview of the type of content that is within the scope of copyright from Tomoaki, I'd like to just flag one reminder, I guess. A quick reminder here is that it's worth noting that when an item in your collection, when you're looking at an item in your collection, it may actually incorporate multiple copyright protected elements within the same object. So, a piece of content or something that you might hold in your collection has the potential to have a number of underlying works or creative copyright protected material layering within that same object. So while you may be thinking about getting permission for the material, it may be that actually there could be multiple potential copyright owners who have interests in material in the same object. So if the content in question is not protected by copyright and there's no other area of law that applies, say, for example, patent or trademark or something like that, then generally you might be able to use the content. If it falls within the scope of what is protected by copyright, then you need to ask yourself the second question. So the second question is, has the duration of copyright expired for the content in question? So if something has expired, then that's a very different situation to when it's still within the scope of copyright duration. So we know that copyright in works carries on after the death of the author. As Tomoaki mentioned, it's typically the life of the creator plus 50 years, and in some countries, some situations, life of the creator plus 70 years. You're talking about a fairly significant period of time in which copyright duration continues in material, in particular after the death of the creator. So if the copyright period has ended and the content has passed into what's called the public domain, then generally you can use that content in any way that you like. If the content is still within the duration of copyright, then you move on to question 3. So question 3 looks at whether or not your collecting body or your library or archive, some other memory institution that you're working with, has permission to use the content in the way that you want to use it. So here you're thinking about whether or not your organization has permission or approval to be able to make the uses that you want to make. So generally speaking, you can do whatever you have permission to do. So it always helps to think about or identify whether or not there might be permissions that have already been gained or collected by your institution in relation to the content that you're investigating, and look to the terms of that arrangement to determine if what you want to do now, if your intended use, is covered by the scope of the arrangement that may already be in place. Permission can be in the form of an assignment, which is where the copyright is transferred in whole to another party, or it could be in the form of a license, which may give specific uses on a number of different terms. Common sort of terms of licenses include things like geography, what kind of part of the world or area does the contract relate to, time, so what duration or period of time does the contract relate to, and what types of uses are you able to make under the terms of the license? So what's permitted and what's not permitted within the scope of the license. And also commonly, licenses will make a determination on whether or not the arrangement in place is exclusive or non-exclusive. In other words, whether only the person with the exclusive rights can make those uses for that period of time in that territory, or whether or not in a non-exclusive arrangement, other parties can make similar uses if they are granted a separate permission. Alternatively to getting a license directly from copyright owners, which may form part of the kind of policy or procedural matrix of your organization, how you handle rights management. So things like your deposit forms, deed of gifts, other types of arrangements that you might have in place. These are all examples of a direct permission from a copyright owner. Alternatively to them, there are other types of blanket arrangements that may give rise to a permission. This could include standardized licensing available from a copyright owner, such as a news publisher, for example. It may also include a permission that's part of the operation of a statutory licensing scheme, for example. Or it could come from a collecting society which administers a voluntary collecting licensing arrangement on behalf of its members. And similarly, a copyright owner may have granted a broad permission to the public to use material under an open content licensing system like the Creative Commons licenses. Some of you may have noticed that the images that I'm using in this presentation are all Creative Commons licensed, and I've attributed them there on the side. So when you're kind of thinking about whether or not your organization has a permission, as long as the use that you want to make falls within the scope of that permission, then you may be able to use the content in the way that you like. Of course, there are lots of situations where your organization doesn't have a permission, or perhaps the intended use that you want to make falls outside of the scope of the permission that you have. In that case, you have to look to question 4. And question 4 is focused on whether or not a copyright exception applies. So before I mentioned the idea that copyright is a balance between the incentive to create and access to knowledge. And so copyright exceptions are one of the ways that countries typically manage the balancing of copyright. So they use copyright exceptions as a way of kind of evening out the copyright system in order to ensure that public interest is still accommodated within the scope of the copyright system in the domestic legislation. So these types of copyright exceptions are typically introduced through some sort of legislative instrument, such as within the Copyright Act itself or an amendment to the Copyright Act. Now, often libraries and archives can typically rely on fairness-focused exceptions, such as a kind of open-ended fair use style exception, or purpose-based exceptions such as fair dealings, which is the kind of system that we have in place here in Australia. So many countries have enacted specific exceptions for libraries and archives separate to these kinds of fairness-focused exceptions. So there is a number of exceptions that come into play for libraries and archives. But one of the interesting things, or one of the problems that comes up internationally when you're thinking about the application of specific exceptions for libraries and archives, is that they don't tend to be typically consistent from one territory to another, from one jurisdiction to another. So while lots of countries do provide an exception to copyright, or a number of exceptions to copyright for the purposes of libraries and archives, how that plays out on the international scale actually doesn't necessarily tend to be fairly consistent. So, for example, Kenneth Kruse, who's an academic who's done a lot of work around libraries exceptions across the world, the most recent edition of their study on copyright limitations and exceptions for libraries and archives, which was published in 2017, reveals that the 2 most common libraries and archives exceptions across the 191 WIPO countries is focused on providing access to collections material for library users and preservation or replacement of materials within the collection. So these 2 tend to be the most common exceptions that you do see across countries. But so for comparison's sake, let's also have a look at what's commonly called document supply and often goes in tandem with what's called interlibrary loan. And let's also have a look at the idea of an exception for the purposes of research and study. So copying for research and study, or sometimes could be referred to as private study, or could be a combination of both. So these 4 exceptions, just as a simple example, give you a bit of an indicator of the difference in the way that libraries and archives exceptions play out across countries. So I've just selected a couple of countries at random from across the Asia Pacific, and using Kenneth Kruse research, I've explored the types of exceptions that are in place in some of these territories. So you can see, a number of different countries have very different approaches or different ways of handling exceptions for the purposes of cultural collections like libraries and archives, and that this isn't consistent even here within the Asia Pacific or across all of the kind of WIPO or Berne Convention countries. So you can see here I've provided 5 of them, and there's a fairly inconsistent mix of countries that are providing a whole set of copyright exceptions for libraries and archives. So the 4 examples of exceptions that I've provided here, you can see are pretty hit and miss in terms of what countries do or don't provide that exception. And expanding that out to some other countries within the Asia Pacific, you can see a similar sort of picture arises. It's not necessarily a consistent approach to the way that different countries handle and introduce copyright exceptions for the benefit of cultural collections like libraries and archives. So you can see there, some countries don't even take the approach of specific exceptions for libraries and archives at all. For example, they might provide a broad license for libraries in general, or similarly for a prescribed set of libraries or archives. So I guess while it's important to think about exceptions as one of your questions in terms of handling and managing rights management within your collection, it's important to know and understand what the exception matrix for your country, your territory looks like when applying that final question. So while I'm giving you a kind of broad set of questions that you can apply when thinking about managing your rights management, some of that will be heavily dependent on the actual way that copyright plays out in your country's domestic law. So I'm almost at 15 minutes, and I'm going to try to stick to time. So I'm going to leave it there, but certainly I'm more than happy to take questions at the end. Certainly thank you all for participating today. There's a couple of additional attributions which I need to make sure I flag in order to comply with the licensing arrangements for those. And just finally, there's some contact details for the Australian Libraries Copyright Committee. I'll be sticking around for the Q&A at the end, and I'm certainly more than happy for people to reach out to me at any point. No worries, thank you. I'll just stop my screen share for you.
Thank you so much, Elliot. That's very precise steps of how people can work on their collections and about the copyright, address their copyright questions. So for all the participants who have questions to Elliot, you're welcome to leave them in the Q&A. And I see there's already one question there, but addressing to Tomoaki. So we will leave that until the end of all the presentations today. There will be a Q&A session. So please stay with us. And thanks again to Tomoaki and Elliot. So now we are going to welcome our third speaker today, Bridget Vizina. She's the Open Policy Manager at Creative Commons. Bridget is passionate about all things spanning culture, arts, handicrafts, traditions, fashion, and copyright law and policy. She gets a kick out of tackling the fuzzy legal and policy issues that stand in the way of access, use, reuse, and remix of culture, information, and knowledge. Before joining Creative Commons, she worked for a decade as a legal officer at World Intellectual Property Organization, and then run her own consultancy advising Europeana, Spark, Europe, and other on copyright matters. So Bridget will present the CC licenses and tools and how GLAM institutions can use them to release their collections using these licenses and tools today. Bridget, the floor is yours.
Thank you very much, Yifan. Thank you for the introduction, and thank you for the invitation. It's a real honor for me to participate. I'll be sharing my screen, and I hope that you... Can you see this? Yes? Okay, perfect. So I'm really thrilled to be talking to you about Creative Commons and how it can help cultural institutions in sharing the collections online. I'd like to start with a very brief introduction of Creative Commons. Of course, it's an organization that's well known for the licenses, but it's also more than that. So of course, the licenses and tools, I'll be speaking in more detail about them later on, are the most famous aspects of Creative Commons, but you also need to know that we also offer training on the licenses through the CC certificates, and that's a very good way to actually understand how the CC licenses can apply on the ground. We have special certificates for educators, for librarians, and there's one that's designed specifically for practitioners working in GLAMs that's in the making. CC also has a portal called CC Search, and that's meant to be to make openly licensed material, including a lot of cultural heritage materials from several GLAMs collections, easier to discover and use. And I encourage you to take a look through CC Search. You might find interesting pictures for your next presentation, just like Elliot did in the presentation before me. I also want to say that Creative Commons is an open GLAM leader. I'm sure you've heard in past versions of this webinar that we're doing quite a lot in this space and in collaboration with UNESCO, as this webinar series illustrates. We also provide tailored advice to GLAMs to help them release their collections online through CC tools. Earlier this year, over 100,000 items were released from Paris Musée, so the museums in Paris, making them freely available online. Also this year, at the beginning of this year, the Smithsonian, which is a huge cultural heritage institution in the United States, made available 2.1 million images, releasing them publicly for anyone to access freely. And another example is the Rijksmuseum, which is a very big museum in the Netherlands that holds a lot of paintings from Old Flemish and Dutch masters in particular, but it has a very vast collection. Also offers all its digitized reproduction of the works in their collection using the CC0, so the public domain statement that I will talk in a little bit more detail about in just a few seconds. Last word on introducing Creative Commons. We also work a lot on policy. So we try to drive policy change in support of GLAMs. So we really think that copyright system, as Elliot and Tomoaki presented to you before, needs to be fair and balanced, and it has to support the legitimate activities of GLAMs. So we are involved in formal processes such as at the World Intellectual Property Organization, within the European institutions, etc., to make sure that copyright law is a balanced system that not only favors creators and supports their creativity, but also makes sure that the general public has access to these works, notably through exceptions and limitations. And what we've noticed is that while new technologies such as digitization and the internet enable, copyright tends to hinder. The reason for that is that copyright was created some couple hundred years ago, where of course new technologies did not exist. And many of the rules are just designed to operate in the analog world. And when new technologies facilitate the creation, the sharing, the reproduction, and many types of reuses of copyright works, the copyright system can't handle it. It just is not designed to provide a set of rules that would actually permit those kinds of activities. So we see that there's a mismatch between what new technologies allow us to do and what the copyright law allows us to do. And that's why I think Elliot was illustrating that without exceptions and limitations, GLAMs are quite limited in the activities that they can do for fear of infringing copyright. So we are actively engaged in making sure that these laws are updated and actually can operate in the digital environment. Now, if I pause for a moment, and I invite you to think about 3 things that you want to take away from this presentation. I'll say these 3 things, and I think these are really the most significant items that I'd like you to remember. First is that GLAMs, so cultural heritage institutions, are entrusted with our collective memory of the world. And digitizing that memory should be the highest priority. I may be preaching to the converted because I know that you are involved in UNESCO's Memory of the World, but I think it bears repeating. Second, digitized cultural heritage material should be held not only for preservation purposes, but also they should be made accessible online in the broadest way possible. Because as Elliot mentioned, it's one thing to keep a copy so that it doesn't deteriorate or it doesn't get lost, but it's also very important as part of this balance that the public has access to the works held within cultural institutions. And lastly, the Creative Commons tools are by far the easiest and simplest means to communicate to the public what uses can be made of this digital cultural heritage material online. They're becoming the standard for GLAMs that are opening up their collections on the internet, and they help them overcome all the barriers that are erected by copyright law in enabling broad reuse. Now, I said overcoming all barriers. I should rephrase that, some of the barriers, but at least it makes it a lot easier. Because once a GLAM has put its collection online, it also has to indicate to the users what they can do with it. Can they just view it? Can they download it? Can it copy it? Can they share it with their friends? Can they use it as an image in one of their presentations? Can they print it? Can they use it commercially? Can they use it for teaching? All these kinds of uses must be clearly indicated to the user so that there's absolutely no doubt for them, so that they can be confident that when they see a work that they like, that they would like to use, that they are confident that they can do so legally. I'll go quickly through the Creative Commons licenses. It's very technical, so I won't spend a lot of time on this, but I just want to give a very short snapshot of what they're meant to be doing. So the Creative Commons licenses are meant to be used by the owner of copyright and makes a decision to grant permission to others to do certain things. So as a creator, copyright law gives you all sorts of exclusive rights, like Tomoaki said. You can actually prevent others from copying, from adapting, from communicating. There's all sorts of things that you as a creator are the only one who is allowed to do them. Now, by using a creative license on your own work, you actually allow everyone to do these things. You apply Creative Commons license on your work. You allow people to copy it, to share it, to make adaptations. Now, there are different licenses, and depending on the licenses that you choose, you will be allowing others to do certain things and not others. And there are 4 conditions, and that's what you can see now on your screen. The first one is attribution. So when you use this condition in the work that you license out, that means that you want people to attribute you. So this presentation, for example, the one I'm giving you, is released under a CC BY license. That means that if you want to use my presentation, you're allowed to, but you have to acknowledge that I'm the one who created it. So you have to cite my name when you share it with others or when you copy it. Share alike, that means that if you release your work with a license including this condition, that means that you ask others to also share it under the same conditions if they create an adaptation. So if you want, let's say you release something and you want it to be non-commercial and you share it as non-commercial share alike, then others that are creating a work based on this CC release work will have to also have this non-commercial condition. Non-commercial means that you cannot use it to make a profit. That's in very crude terms. It, of course, can get more nuanced than this. And no derivatives means that you don't allow people to make adaptations. And the classic example of an adaptation is to translate something. So if you don't allow others to make adaptations, people cannot make a translation of that work without your permission. So by mix and matching these 4 conditions, we end up with 6 different kinds of licenses. And on the next slide, you will see that they are ranked from the one providing least freedom to users to the one providing most freedom. So the most restrictive license will be the one that has to, where the users have to attribute, they cannot use commercially, and they cannot make adaptations or derivatives. And then the one allowing most freedom is called the CC0, or Public Domain Dedication Tool, where as a copyright holder, you actually relinquish, that means you abandon all your rights. You say, I will not enforce my copyright on this. I release my work into the public domain, allowing everyone and anyone to make any kind of use that they want with this work within the copyright system. Now, what does this mean for GLAMs? Actually, there's all kinds of content that GLAMs can make available online, and I'll focus on one of them. It's materials that are in their collections and that are in the public domain. There are no longer, or there never were, any copyright rights attached to this material. So either it's very old, it was never protected by copyright because it even predates the invention of copyright. We can think about very, very old objects, or very, very old manuscripts, or very old paintings or sculptures that are so old that they were never protected by copyright, or some that were at some point in time protected, but protection has expired. They have, as we say, entered the public domain, and therefore they are free to be used by anyone. So this is a little less complicated than works that are still under copyright, where you have to go through all the questions that Elliot mentioned. So these would have had a no at the first or the second question that Elliot mentioned. So they're not material protected by copyright, or the copyright has expired. And if you remember only one thing from this presentation, may it be that digitized public domain works must remain in the public domain. So it's not because you digitize a work that's in the public domain that you can create another layer of rights and claim rights over that digitized object. If something is in the public domain, they have to remain in the public domain, even online, even in digitized form. And the way that you can indicate that these digitized forms are also in the public domain is by using one of two of Creative Commons tools. The first is the public domain mark, and the second is the Creative Commons public domain dedication tool, or CC0. So either of them can be used by GLAMs to indicate that the cultural heritage collections that they are sharing online are in the public domain. Now, what's the difference between the two, and how do you know if you should use the PDM or CC0? It's actually not a straightforward question. It's quite heavy on the question. The answer, is quite dependent on the context. But let's start with the easiest, the PDM, public domain mark. It's a label. It's not a contract. It's not a license. It's just a label. It's almost like you just put a sticker on a work that you put online. It doesn't have any legal value. It's just an indication to the users that the works are in the public domain worldwide. Everywhere in the world, there are no copyright rights that attach to this work, and anyone can apply this PDM. It doesn't have to be necessarily the institution, or it doesn't have to be the copyright. Well, there's no copyright owner, but that doesn't necessarily have to be the cultural institution that holds that object. Now for CC0, the public domain dedication mark, that can only be applied to works that are under copyright, not to those whose term of protection has lapsed worldwide. If there's no copyright to begin with, there are no rights to license out, and there are no rights to abandon. Now, this contradicts what I just told you, right? Because if we're talking about works in the public domain, how can there be a copyright owner? How can there be any rights to dedicate to the public domain? Well, the reason is that in some countries, making a digital reproduction of a work in the public domain can generate a layer of rights. In other words, you have an object in the public domain, you make a photograph or some kind of scan, digitization of this digital surrogate that we call, so it's the digitized version of that work may be protected by copyright. Only that digitized version. Now, at Creative Commons, we say it's in the public domain in analog form. It has to be in the public domain in digital form. And the way to do that is to apply the CC0 on this digitized version to make it crystal clear to everyone that by doing that, we're putting it in the public domain and any use is possible. So again, just to re-emphasize, because this is something that comes up quite often, why do we recommend using CC0 over the public domain mark when we are talking about works in the public domain? Is because, yeah, the reproduction itself can be subject to copyright. And it's really an indication that the institution says we might be holding some very thin copyright in certain countries on the reproduction. And by applying the CC0, we say that we will not enforce these rights. We remove any doubt for the users that might think, well, in my country, digital reproductions are protected by copyright. Does that mean that I can use it freely? By applying CC0, it makes it clear that anyone can use it. If you're interested in knowing more about the differences between CC0 and PDM and you're not sure which one to apply, there's a quite handy table that's available on the wiki website of Creative Commons, and it compares the features of the public domain mark and public domain dedication, and you will see it goes over the issues that I already mentioned. But you have to remember that the public domain mark is just a label, and the CC public domain dedication is a waiver. It's a real contract that's enforceable that you can only use if you own the rights in the object. Now, this is the theory, and the theory is often very different from the practice. I like this quote. It says, if in theory, there's no difference between theory and practice, but in practice, there is. That means that the theory is as I just presented to you, but in practice, there are many other considerations that arise that make determination a little more difficult. So I provide you with a series of links here if you want to delve deeper, an FAQ on what CC0 and PDM mean, the chart that I just presented to you comparing the two instruments, public domain guidelines. So once something is released in the public domain, people can use it freely, but there are still some guidelines that we encourage users to follow. And for example, to attribute or to say, well, I'm using this photo, but I actually downloaded it from this GLAMs website. It's a nice practice to acknowledge where you got it from, where you sourced it from. The recommendation for using the CC0, as I mentioned, over the PDM, just to dispel any doubts. A blog post stating that public domain works should remain in the public domain and giving more arguments why that should be the case. And then a blog post also on sharing indigenous cultural heritage material, because we've only been talking about copyright and the restrictions of copyright so far. But it's important to know that copyright is just one system that governs use of cultural heritage material, but some cultural heritage material might be subject to all sorts of other restrictions, either stemming from indigenous peoples' customary law, protocols, and other sources of law that need to be respected. So that's all I have to say, and I look forward to your questions later on in this session. Thank you very much.
Thank you very much, Bridget. There is actually a very quick question from Rashmet addressing to you directly. He or she, Rashmet is asking if the person modified public domain works, can the person use CC BY SA licenses to the newly created work? Can you just quickly address this question?
Yeah, so it will all depend if this adaptation is also original enough to be qualified as a copyright work. So if you add enough elements in your adaptation to the, so let's say you use a public domain work and you add enough original elements yourself, those original elements can be protected by copyright. So your adaptation will be partially protected. The public domain elements will remain in the public domain, but your contribution may be subject to copyright, and you may be able then to apply a CC license to those elements and allowing others to use that adaptation of yours.
Thank you, Bridget. And Rashmat, hope this answers your question. So if you have any other question about CC licenses and tools and the public domain mark, you can leave them in Q&A, and Bridget will be able to answer you in the Q&A section after next presentation. So now, last but not least, we have our fourth speaker today, Dr. Partha Pratim Das. He is the Joint Principal Investigator of National Digital Library of India project of MHRD and leads the initiative to integrate the digital repositories of various institutions, agencies, and publishers across India. He's a professor at the Department of Computer Science and Engineering in India Institute of Technology, Kagapur. I hope I pronounced it right. And also heads the Rajendra Mishra School of Engineering Entrepreneurship. Dr. Das received his BTech, MTech, and PhD degrees from IIT Kagapur. His current interests include computer analysis of India classical dance, technology-enhanced education, and software engineering. Dr. Das is also a member of the steering committee of Rights Statements Consortium. So today he will give an introduction of Rights Statement Consortium and the tools. He will also talk about how GLAM institutions can use these tools, as well as how rights statements and CC licenses interact. So Dr. Das, please take the floor.
Thank you, Yufan, for a very nice introduction of myself. Welcome, everybody. I would just like to specifically highlight that in spite of my multiple affiliations, I'm here today representing the rightstatements.org, that consortium, presenting about the proposal of right statement. So we have had three very excellent and synchronized presentation till the time with the Professor Tomoaki presenting the foundational concepts of copyright, and Elliot raising different issues that GLAM has to address in terms of assignment of rights, and Bridget taking us through the availability of gradations of open licenses. In this context, I would like to talk about this right statements consortium and kind of the right statement movement, which tries to make it easier for cultural organizations across the globe to share their valuable content by providing a range of standardized statements. So the basic issue that we'll see here is there are several situations where the copyright status is known. So I'm just trying to give the basic essence at the beginning. It is known in the sense that the copyright is held by somebody in some form, etc. There are different shades. We can talk about it. So those could be in public domain, those could be under CC, those could be under specific copyright laws of the geography. Or it could also be that the copyright is actually not there. There's no copyright held by someone, and that also is known, established. So these are clearer cases which do not often need any separate treatment, and particularly when we talk more about the scholarly publications and things like that, most of the content, most of the elements fall within any one of these two. So the handling of the content with respect to whether the copyright is held or it is not held, and if it is held, then how it is held, how it can be used, becomes still less of an issue. But when it comes to cultural heritage organizations, we'll see the general experience is there is a third gray area that people often have to deal with, where it is not known whether the copyright is held by someone. It is neither known that it is free of copyright. So that big gray area turns out to be a big concern. Now, so it's a concern for really not only limited to cultural heritage organizations. For example, I would this is with very direct reference to the general protection period of the Copyright Act, which Professor was mentioning, 50 year plus to up to 70 years. So that has naturally, this is the statistics of the European data set, which is a leading organization in cultural heritage in the digital space, that if you compare the access from 1800 onward, there's a period in 20th century, which is where the access is very, very low. And that is what is called the 20th century black hole, or if you look in a different representation, which comes from Trove, the Australian newspaper collection, you'll see that there is a very high rate of access up to a certain point, and then it suddenly drops off. The reason is simple. Whenever you come into that period where you are within the copyright range of 50 to 70 years, naturally, most of the useful contents cannot be accessed in general. So, I mean, books vanish, so does very similarly the cultural heritage items get out of copyright. So that's kind of a big concern area for the cultural heritage organizations, based on which the whole objective of the right statement has been to encourage the use of this rights information. Now, naturally, you could say that, well, if it is not known, or if it is known as to what the copyright status is, people can just write it down. Yes, people certainly can just write it down. But the problem that primarily starts happening is when people keep writing down the copyright status of different items, they start putting in descriptions. And at times, those descriptions have become even longer than the abstract of that item, or the proper description of that item. And several statistics computed in collections like in DPLA or New York Public Library has shown that there are thousands and thousands of different descriptions have been put to mean different copyright status of items where ascertainability of the copyright was not clear. So standardization becomes a very big question and a very big part of the objective of the right statement. And certainly the second part is dwelling in the digital domain. It is not always not preferable, not scalable, not possible that always the rights information will be looked up by a human being. So if you standardize the expression of rights, you also need that the rights expression must be readable in digital form so that machines can check out. If I'm asking for a content with a GLAM X, and GLAM X actually finds it in GLAM Y, so the GLAM Y has put a standardized expression of right on it, then the server in GLAM X must be able to read the server in GLAM Y to understand what that right statement means and what kind of rights behavior that can be provided. So that has been the main objective, and naturally, I will try to answer this basic question of how you can use this right statement. So right statement, so with all these feelings, all these observations, across different GLAM organizations, the two big cultural heritage organizations, European and DPLA, formed a consortium to establish the right statement, where this was the objective, to standardize the rights, statements of rights that are required for the cultural heritage institutions. Subsequently, naturally, other organizations started joining. From India, the National Digital Library of India was the next to join the consortium, which has been followed by National Heritage Digitization and Strategy from Canada, and Trove from Australia. Recently, actually, Digital NZ from New Zealand has also joined the effort. So just to give a basic idea of the consortium is all members of the consortium, it's still a small one. So all members of the consortium has a seat in the steering committee, which finally manages the whole rights statement. So from NDLI, I'm one of the members of the steering committee. And then the actual work on the rights statements are done through two independent working groups. One group is called the Statements Working Group, who are continuously working on assessing the righteousness of the right statements, the appropriateness, how it can be adopted. And for example, as we go to different geographies, different kind of alignment and conflict arises with the respective copyright law of that geography, with respect to what is traditional knowledge, indigenous knowledge. In several geographies, indigenous knowledge is just amorphous, not structured. In certain geographies, is very well structured, and so on. So Statements Working Group continue to work on the relevance, appropriateness, and applicability of these statements all through. And also, they also facilitate translation of the statements in multiple languages, because when you want to apply the statements in different geographies, it is preferable that the statements be available in the predominant language of that geography. The other group, which is a technical working group, primarily manages the infrastructural issues of the right statements. As I mentioned, the right statements are intended to be in the form of machine readable statements. So they must be exchangeable in that manner. So there has to be a server properly which does look at this in the form which can be decoded very easily and passed on and so on. So the technical working group primarily works and manages those aspects of the right statement. So now it comes as a part of the overall presentation. Certainly, I'm not going to talk on this because we have just heard an absolute expert on CC. So we know that Creative Commons are licenses that can be assigned by the creator. Right? So, so that is great, and in many cases that's very effective, and we have seen all the different shades, properties, attribution, and all those in this. But the difficulty is it does not always reflect some of the common copyright situations that are faced by GLAM. So if you're talking about, if we open up the spectrum of data that GLAM deals with, so one is certainly the metadata of the objects, which is typically owned by the institution, so they can be kind of put into CC0, not a problem. Then there are collections, which have different possibilities. One is they could be in the public domain, much like any other. They could be owned by the institution who is hosting them. So these two are clearer situations, but there are situations where, particularly in cultural heritage, it is unclear as to what is the copyright situation. Does the rights exist with someone, or does it not exist with someone? You have not an answer to either of the question. Neither you know for yes, nor you surely know for no. And the other situation could be that the copyright actually belongs to the third party, who is, may not be the creator, but may have acquired that right at a later point, and it needs a different kind of understanding and negotiation to actually get that in the right fold of rights in the GLAM. So owing to these requirements, right statement currently has 12 different statements grouped into 3 categories that I have been talking about. One certainly is the statements that are in the copyright. So there is a whole lot of items that are in copyright. So you put one of the statements from this group on items that are in copyright. Then there are statements which relate to for items which are not in copyright. But in both these cases, you have a complete knowledge. You know that it is. In the first case, you know it is in copyright. In the second case, you know it is not in copyright. And the third group, the very important group for right statement, is statements that work where the copyright status is unclear. You do not know what they are. So this is just kind of showing a geographical proliferation of right statements. So Europeana has been the founding member from 2015, and they have applied and adopted right statement to about 24.2 million objects that are published today. So there's a huge, large set of objects where these statements have been tried, and it has been, of course, statistics looked at as to what works well, what does not work well, and so on. Similarly, this is from Canada, NHTS, who are a member from 2016, and they have worked on some early adoption. They have worked on a French translation, like from NDLI India, we have worked on a Hindi translation because our region needs Hindi as a main language. Now, this is also something about the dichotomy between the rights on the original work and the digital object, which I do not think I'll expand anymore because Brigitte has done this treatment very well. I will just focus on the fact that which I've been talking about, that every right statement exists in 2 forms. One is machine readable, which is, for those who are inclined, it is in RDF, and the other is in HTML, which is for the humans too. So they are in sync of both, and so this is how the right statement will look like. You can go to the site and you'll be able to see the statements one after the other. So this is how the statements are. I'll not go through. This is just a translation, just to show you that there are several multiple language translations exist. So I'll just quickly summarize and end with the statement. So this is for statements for the objects in copyright. So this is the simplest case where something is in copyright according to that. There is a separate statement which is very specific to European Union because of the specific characteristics of the orphan work. So there is a set of statements for EU orphan work. Then there's copyright for when it is known that the copyright is held, but it is not known who holds that. So you have a statement which is unknown copyright. Then the remaining 2 talk about where the educational use is permitted. We have heard about exceptions, fair use exceptions, and so on. So kind of a very similar concept, but you are specifically saying that this culture heritage item has copyright, but the educational use of it is permitted, or in some other case it could be non-commercial use is permitted. So that's what makes your the expression of statements in the copyrighted objects very, very clear. The second group talks about objects that are not in copyright. That is, you know that they are not in copyright. So it could be that they are not in copyright, but may be specified for only non-commercial use. So you specify this statement. It could be that they are not in copyright, but I think Professor Tomoko at the beginning talked about that copyright is not the only right that applies to an item. There could be several others. So there could be other restrictions. There could be other contractual restrictions or a specific statement for the United States. Finally, the other statements where the clarity is not there, which adds a lot of value, where it is either the copyright has not been evaluated, or they have not been, they have been undetermined, or there is no known copyright. So these are the different shades of what the right statement is trying to deal with. It is for the organizations to deal with that, and does not contradict with Creative Commons or public domain tools. So often organizations have a choice to pick up part of the Creative Commons or whole of the Creative Commons alongside the right statement and make their own basket of rights statements. Details are available on the site, and I've already crossed time. So thank you. I will stop at this point.
Thank you so much, Partha, for the very comprehensive introduction to right statements. And I learned a lot. At least now I know that not only Creative Commons licenses, but also these statements from right statements could also be used to protect sort of copyright, and also could promote open access to some collections of GLAMs institutions. So now is the time for Q&A. I see there are already 4 questions posted in the Q&A function by the Q&A function, and also 1 question posted in the chats. And I see that actually our speakers has already addressed them. But I think for the question that Misako posted in the chat box, maybe, so what she asked is a question to all panelists regarding the copyright that applies to digitized materials in the culture sector, photography, for example. When the original works are in the public domain, does the copyright apply to the digital representations of these works? And Elliot and Tomoaki has already answered them in the chat box. If you are interested to see their answers, you're welcome to go back to the chat box and to see their answers. But maybe any of the speakers you would like to add something to the question? To the answers? I mean, sorry. No, then let's move to other questions. So there is a question from Mohammed to Bridget. So in the history of copyright, is the layer of the copyright evolved, added, and or changed or modified?
Thank you for the question, Mohammed. Yes, absolutely. Through the course of history, copyright law has evolved. It may have started with simply a reproduction right, and has over time added several types of rights to the bundle. As Tomoaki showed to you at the beginning, copyright is not just one right, and it's not the right to copy, as many people might think. It's a right on a copy, but let's leave that aside. And copyright law now might include the right to reproduce, or to make adaptations, the right to display, to perform in public. Several different rights may attach to an object. There's also what we call related rights that are not copyright in the strict sense, but for example, a singer who sings a song that is not his own composition, but might sing the song of somebody else, might have rights in that performance. That's what we call a related right or a neighboring right. For record companies, they might also have a right on the record itself and not necessarily on the song. So yes, of course, it has evolved and it continues to evolve. Just recently in the European Union, last year, a new directive was adopted, creating a new right. And that right is for press publishers. So you may have heard of that companies that are media companies that share news online have been awarded a new right just on their press publications. So obviously it's constantly evolving. The trend is that it's creating more rights rather than creating more limitations and exceptions, and that's a trend that we aim to correct.
Thank you so much, Bridget. And Mohammed hopes this answers to your question. And there's a question from Meika Luin actually, the person is asking to get the slides of all the speakers. I see actually the slides of Tomoaki, Elliot, and Bridget are already shared in the chat. So I'll send a message to like compile all the links and in the end, so you can get them easily. And I see there's a question from Yoko Saiko in the chats. Do we have access to write statements online? That was a great knowledge, rather new to me. So Dr. Partha, a question to you.
Actually, there is a complete website on write statement where you get the statements in every form in about 10 different language translations. So that you can just search writestatements.org and get that. In my presentation, in the last slide, that link is also provided. So you'll get all the background information, the details of the statements, the RDF form in multiple languages as well to refer to and how to use them. And naturally, not the information about the consortium, because we specifically maintain only the right statement focus, but all that information is on the website. Thank you.
Thank you, Partha. So is there any other questions? I think please use the Q&A function or the chat box. We'll give like 1 more minute to pose all the questions. Actually, I have a question. So maybe to all the speakers. I'm also curious, for example, if I'm a big fan of cultural contents of museums, and I go to different museums to take photos of different artworks or sculptures, and I want to make them all together into a compiled work. In the end, for example, I take the photo of Mona Lisa, and I take the photo of Eiffel Tower, but the lightning like in the night of Eiffel Tower. So and also other pictures, and I want to put them together and make my own creation. But some of the content are already like they're not really they're in the public domain, but some others are still protected by copyright law. So in that case, how can I do to use? Can I just use those photos for freely? Can I publish my work in public domain as well? Can I, or what type of licenses or tools that I can use?
Okay,
I can start.
Oh, okay. Go ahead, please.
No, please go ahead.
Okay, so let me make a first shot and pass on to Bridget. So first of all, there are some copyright exceptions in many countries, often referred to as freedom of panorama. When you wanted to take a piece of architecture in the public space, maybe it's okay to do it. You know, taking a picture is an act of reproduction. So usually it needs some kind of license. But in case of taking a picture of publicly available architecture into a photograph, maybe it's okay. And as a result, as a part of the exception, publishing that photo may be okay. So that's one part of the answer. Another part of the answer is that when you faithfully reproduce 2D works, such as a painting, into a digital photo, you may not create extra layer of creativity by yourself. For therefore, as Bridget mentioned in the previous answer, maybe that photo is not your own work. It's not like a modification. So it remains in the public domain in that case. On the other hand, if you photographed some sculpture, then it's a three-dimensional work, and the way you set the angle, for example, may give rise to copyright, because that's based on your way of capturing the work, and maybe there is some minimal level of creativity in it, or maybe not. It depends. But the collection as a whole has apparently works of different copyright status, and representing the whole collection with one like single copyright statement in any case is very misleading. So you have to kind of itemize which part of the collection it has which kind of copyright status. So that's number one. And number two, aside from that, many countries recognize copyright in compilation. So if you pick and choose the photograph to curate a collection which represent your ideas of, I don't know, maybe your things you love, or your journey throughout some museums, maybe that in itself, the collection is a copyrightable thing. So aside from copyright status of each individual photographs, uh, collection as a whole may be your copyrighted work, and therefore other people may be able to copy one part of the collection, say public domain photo, but then copying the whole collection altogether may require your license. Okay, so that's my attempt. And now the mic is yours, Bridget.
Well, that was so comprehensive. I don't have much to add, but I just want to make it clear that once you when you take a photograph of a work in the public domain, you don't have to ask permission. You can do it. You can also publish it. There is absolutely nothing preventing you from doing that, apart maybe from the museum's rules. Sometimes they will say no photographs, even though there's no copyright basis to that. To forbidding photographs. It's just their policy. So you have to be careful about that too. About the Eiffel Tower, that's a funny example, because the lighting show at night is actually a copyright work. So the Eiffel Tower might be in the public domain. However, this lighting show that they have at every hour, I think, has been claimed to be a copyright work, and therefore you would have to ask permission of the management of the Eiffel Tower in order to publish pictures or videos of the Eiffel Tower displaying that. And then if you want to make a compilation of those, well, if you want to add the pictures of the objects that are in copyright, then you have to ask permission to every single copyright owner for including that in your collection.
Thank you. Thank you so much.
I was just going to say, I would add one thing to that as well, that for works that are still within copyright, there is a potential that your use may be permissible under an exception. For example, here in Australia, we have an exception for criticism and review. So if there's a kind of level of commentary or critique of the contemporary works that are under copyright in your compilation, your use may be permissible. However, if literally just straight images of copyright protected works, then as Bridget has identified, you would likely need to get permission from the copyright owner for that. But also, certainly, if you were relying on a copyright exception like criticism and review for your use, that doesn't give you the ability to assert copyright over those images in the work. It just simply gives you an ability to use that copyright material for the purpose of criticism and review.
Okay, thank you, Elliot, for that adds-on. And I see there are a question in the chat from Jessie. Hi, I'd like to ask, is it all right to take a picture of a painting or statue and publish it in a form of mobile application and claiming them as your belonging? Thanks. I think that's a question like quite similar to the one that I asked. But, yeah.
Certainly, I'd say by extension, the same sort of response. You can't claim copyright and material that's not your own. Your mobile application, for example, you may be the copyright owner of the code and certain other elements of it, such as the design and visual components of your mobile application, but you still require a permission for the underlying copyright works that you want to display within the mobile application. So you can't claim copyright for things that are not your own. You can only claim them for things that are your own. So as Tomoaki kind of flagged earlier, in a situation where the rights relationships in the material, such as a mobile app, are complicated and there are a number of different potential copyright owners, you should make it very explicit somewhere, an itemized list of who is the copyright owner of what component, so that it's very easy for users to understand what they can and can't do with the material.
Thank you, Elliot. So there is another question. I would say this should be our last question today, as it's already 3:42 now. So this is a question from Eddie. How copyright applied on the access on works such as movies or photographs after a digital restoration by memory institutions? So I guess maybe Bridget, you could answer this question.
Yeah, I think there are so many elements to that question. It's hard to summarize it in just a few minutes. But yeah, the restoration itself would probably not create any new rights. It's just to restore the work in its original state. So if the work is in the public domain, then it will remain in the public domain. However, if the restoration adds original elements, then the restorator might be able to claim rights, but I don't think this is the practice. And that means that that work would remain in the public domain. The digitized version, we encourage it to remain in the public domain. Therefore, that wouldn't change. Now, the question also mentions movies. Movies are so very complicated in terms of copyright ownership. There are many layers of rights, the producers, the actors, as performers. Many people might own rights, maybe in the music score or some performances, as I said. So it's very important to make it absolutely clear that it's in the public domain from all layers of right before we can be sure that it's fully in the public domain. So for audiovisual and cinematographic works, different copyright rules might apply. So please be conscious of that.
Thank you, Bridget. So I think that's, thank you so much. Thank you, Tomoaki, Elliot, Bridget, and Partha. Thank you for all those wonderful, comprehensive presentations today. I learned a lot, and I hope all the participants are the same as me. Thank you so much. And I would like to remind everyone that this is a webinar series. So we will have our third session of the webinar series next Friday, the same time, starting from 2 p.m. Bangkok time. And so next week, we will have a moderated panel discussion, as well as experience sharing presentations from Europeana, Wikimedia Foundation, and ASEAN Digital Library. It will be very interesting, and I hope to see you then.